welcome everybody here again this afternoon for our third webinar since May, actually. That's not too far back behind us on this whole eviction moratorium. We are fortunate today. We have our longtime friend and expert real estate attorney, Shanna Welsh, with us. And I'm going to talk to you a little bit about Christy. Is it Descantis? I don't want to mess it up, right? She'll be joining us today, giving some information on the last few decisions that, if anybody's been tracking this thing, right, last few days have been kind of roller coaster. But NAR has played some strategic roles in some things, and so there's some information that she's going to give us. Christy is the Director of Business and Conventional Finance and Policy with the National Association of Realtors. So she definitely has her hands on this. She's going to help us better understand the administration's recent announcement, as well as the Supreme Court decision, if anybody was following that, that may be challenged on its validity. Again, this is kind of all over the place. These two ladies are going to narrow this down, and I promise you, you will have a better understanding when you walk away today. And the great thing is they actually do Q&A. So make sure that you guys are listening, you're paying attention to the chat, what's happening in there, and this session is being recorded. So if you miss it, or there's some things you want to follow back up on, you'll be able to go back and do that. With that being said, I'm going to have Christy go ahead, jump in, get started on this. She's going to do about a 10-minute update again, and then she'll do some Q&A, and then I'll be passing things back over to our 2022 president, Chris Anderson. This is going to be her second time as president for STAR. She'll be introducing Shanna Welsh, as well as a very good friend of hers and mine. So again, go ahead, Christy. Thank you.
Great. Thank you so much, Carla, for having me here today, and Ryan for reaching out on this. You guys couldn't have timed it more perfectly. Here to talk about what is going on with the latest federal eviction moratorium and the latest action. But even before that, I want to let you know that how focused NAR has and always been on effective disbursement of the rental assistance to get that out the door flowing, which includes ongoing engagement with Congress and the administration to let them know what is working and what is not working with that program, in addition to what is not working with continued eviction moratorium that, as you all know, unfairly shift economic burdens onto housing providers who have been struggling financially throughout this entire time. So apologies again, and I will make sure to share these slides afterwards, as there's a lot of information in here anyway, so it'll be good to have on hand if you can't see it in the clear view that it should be right now. So again, I apologize. But so as you all know, there's been a lot of back and forth going on. And most recently on Tuesday, August 3rd, despite numerous statements to the contrary by the administration, the CDC, that the CDC lacked the legal authority to extend an eviction moratorium, the CDC went ahead and did that. I'll go into more details of the actual eviction moratorium shortly, but wanted to let you know that this fourth extension actually came about a week after the craziest game of kind of finger pointing that we've ever seen, including starting with first multiple statements by the administration saying they did not have the authority to act, and then called on Congress to actually pass legislation midweek last week. That turned then into a last-minute effort in the House to find enough supporters to pass a bill that would extend the CDC eviction moratorium. But thankfully, thanks to NAR, its members, you all, its coalition partners, and their immediate action, saying that the focus should not be on extending the eviction moratorium, rather it should be on getting rental assistance out the door. Congress did not have enough support to pass a bill. And that basically all came down on Friday evening of July 30th, when the House brought a bill to the floor under unanimous consent that would have extended the eviction moratorium, but it did not pass. So following that, the administration continued to make statements about a lack of legal authority, but were under immense pressure from Congress to act now that they couldn't get their bill through. So as a result, White House acted on Tuesday, issuing that new CDC order which unfortunately failed to reveal any new legal basis for such an extension. So what is in this latest order? Well, it's focused on halting evictions in counties with heightened levels of community transition. The moratorium is based on the level of COVID infection rates in a given county, which may be lifted or reinstated based on that rate of transmission over a 2-week period. So if an eviction started in a low-risk county, but then that county becomes high risk per that CDC tracking, it would be subject to protections by the order. Because this map is going to constantly be changing, we can only imagine the headaches it's going to cause for counties and property managers around the country. So that's why we're continuing to assess the actual impact. This order does have similar application as the previous ones in the sense that it's not relieving anyone of rental payments owed and does not preclude the collection of late fees, for example. Tenant declarations are still required and evictions may still proceed for things like contract violations or tenant misconduct. Also, like before, it does not supersede any existing state or local authority that may already be more restrictive, such as what you all are experiencing, and I know what Shanna will speak to briefly soon, all the good stuff coming up. So in terms of completed evictions, it actually occurred in that 3-day window when the July 31st hit and before August 3rd. Those are not impacted, as this order is not retroactive, but it does apply to pending eviction moratoriums or pending evictions if it falls under the subject of this moratorium. Also, as you know, each state or locality also has different judicial eviction procedures in place, and these may also not be affected by the CDC's changing actions here. It's also important to note that while that the order itself states it could be extended past October 3rd, which is why we are supporting continued legal action as well, just as was done previously that resulted in that Supreme Court order on June 29th. We know the president himself stated that this would face obstacles, but in the meantime, we'll be using the time it takes to get those resolved to get more rental assistance out the door. So NAR continues to be hyper-focused on that rental assistance efforts as well, which I'll also touch on shortly to make sure that the Emergency Rental Assistance Program, or ERAP, is functioning efficiently and effectively. But first, I'm going to get to the quick legal update. So to understand where we are now, I want to give a little bit of brief context, but in the interest of time, I'm not going to go through step-by-step history here, but I want to make a few points to help you understand why we are where we are. I'm also not going to speak to the handful of other cases that are going on, working their way through the various circuits, but rather I'm going to focus on that that was filed by the Alabama and Georgia Association of Realtors, as well as 2 housing providers in that state and their property management companies. So as you can see, a few times Congress acted to extend the eviction moratorium. Those directives are not under question in the litigation filed by the Alabama and Georgia Realtors that reached the Supreme Court. It's only those actions in red that the CDC has been challenged in a lawsuit that was actually filed last November. So on May 5th, as you may recall, the U.S. District Court for the District of Columbia struck down the CDC's nationwide eviction ban, concluding that the moratorium exceeds the limits Congress placed on the CDC's authority. But they also issued a stay, which kept that moratorium in place pending the government's appeal. This was a decision on the merits, which the DOJ is still appealing. So the Alabama and Georgia Realtors then appealed that stay to the DC District Court, was rejected there, and then they appealed that stay to the Supreme Court, which issued that June 29th order. And in that order, 5 justices of the US Supreme Court agreed that the CDC lacked the authority to implement a nationwide eviction moratorium. However, another combination of 5 justices also determined that the moratorium should remain in place until its expiration date on July 31st and denied the request to vacate the stay. The Supreme Court did not issue an opinion on the merits there, as that's still being litigated, as I mentioned, pending before the DC Circuit. But we did get some insight into at least Justice Kavanaugh's reasoning with his concurring opinion, which, despite being out there stating you need specific congressional authorization, we still saw the CDC act on August 3rd. So that's the extent of the Supreme Court action, which leaves us where? Well, yesterday, actually yesterday evening, approximately 10 p.m. Eastern, the Alabama and Georgia Association of Realtors filed an emergency motion to enforce the Supreme Court's ruling and to vacate that stay pending appeal with the district court, the DC District Court that I just mentioned. This was not filed with the Supreme Court because the time for consideration has already expired there. And for the Supreme Court to consider taking any action, the plaintiffs have to go back to the lower courts to exhaust all remedies. And if the Supreme Court were to act without a full briefing on those underlying merits, you could run the risk of having an adverse ruling. And again, you're at the Supreme Court, so that would be not only binding supposedly on the administration, but also binding on Judge Friedrich of the US District Court, who issued that favorable ruling in the first place. So that's why this was filed at that district court level. So what exactly was filed? Well, the ongoing lawsuit characterizes the CDC's action as a fourth extension of the eviction moratorium. While the administration claims this is new, it's not nationwide and it's more narrow, it actually has the potential to be ratcheted up to 100% coverage nationwide. And in comparison to the previous orders, it's very similar, but for that coverage aspect. The motion also cites how the CDC's actions with the extensions continue to lack that legal authority, where the CDC again relied on the Public Health Services Act that the district court, the DC District Court, the Sixth Circuit, and the Supreme Court have all found inadequate to justify as a basis for implementing this order. The motion further cites how the CDC's actions are in direct conflict with the June 29th Supreme Court ruling, which stated no extensions beyond July 31st. So the plaintiffs here are asking essentially to block the August 3rd extension and to vacate that May 14th order that granted the stay in the first place pending the appeal that started the initial track to the Supreme Court. We actually anticipate this action to move very quickly. We got notice this morning that Judge Friedrich has already issued an order requiring the government to respond to the motion filed last night by 9 a.m. tomorrow. And then the plaintiff's response is due by 7 p.m. tomorrow night, so same day. So obviously fast developing situation. Want to again flag that in addition to our support for the ongoing litigation, that we are again really focused on rental assistance and making sure that's working. And we're going to continue our mission of preserving, protecting, and advancing private property rights. We really appreciate your efforts too to making sure we're focusing on the issues that matter to you all and your businesses, including how we can improve that emergency rental assistance program. So before I wrap up, I just want to flag a few of NAR's resources for you all on this issue. First, we have this great state-focused policy tracker that highlights COVID-19 issues, and it also includes a new special report put out on the 4th, which is yesterday. Again, all these days are running together, but that's really focused on those state and local eviction moratoria, as well as mortgage and rental relief programs. We also have a state legislative monitor that you all may not be familiar with that comes out every week. It includes topics specifically for housing providers and tenants. So again, I'll be sure to share these slides so you have these links. And there's also a slew of so much more information that can be accessed via text. So if you shoot a text to that, you'll be sent with a bunch of links to additional resources, including a new CFPB tool that was pushed out last week that we provided feedback on to housing providers to better access rental assistance.
Thank you so much. Really appreciate your time. And then now I'm very pleased to welcome my friend and expert real estate attorney, Shanna Welsh-Levin. She has now been with us 4 times. And this is such a pressing issue and topic right now with everything changing, like we just heard nationally. And then now you're going to give us the update on the state and the local and how we can navigate through this for our clients and for our own selves and our companies. So thank you so much. And then also just for you guys to know, as a reminder, this event is being recorded and it will be available on our YouTube page by tomorrow afternoon. And we hope you guys are able to watch this again because it's going to be packed with tons of information. So thank you so much, Shanna. Go ahead.
Oh, thank you so much, Chris. I really appreciate it. I'm happy to be back. I'm going to share my screen because I have some slides for you too, and try to do this presenter view. Hopefully mine works. Gotta move my screens around now too. Must be, it's Zoom today, I think. Trying to get my display settings on the right screen here too. And it's not wanting to do it for me. So if you guys can see, I'm not going to be able to do the presenter view, but if it's okay to just present it like this, hopefully you guys can see my slides. If you can't,
It looks great, Shannon.
okay. All right, thank you. So I'm Shanna Welsh-Levin from SoCal Realty Law with you again to give you an update on all of the California-based eviction moratoria. And we've had a lot of extensions, a lot of changes since May, not just with the San Diego County ordinance, which has actually remained the same, but we're looking forward to the termination of that moratorium. But AB 832 has changed a lot of things. The federal CDC eviction moratorium, as you just heard, and then rental assistance has become a very interesting and active, not an issue, but a success, I think, in this case. So landlords need to know about this eviction moratorium update. And just to get started here, the San Diego County ordinance, I was thinking expired on August 14th. It's never been entirely clear to me or really to anyone else exactly when it began. Well, we know it began on June 3rd, but then the expiration was to be 60 days after the governor lifted the stay-at-home and work-from-home orders. And there wasn't a clear announcement of when that happened, but there was an announcement from the county when that happened, kind of. And then just recently, as I was, updating everything for today, there was a press release 2 days ago from the San Diego County Board of Supervisors indicating that the county ordinance would expire on August 10th. So August 10th seems to be our new date. That's this coming Tuesday. And so if you have been following this, this San Diego County ordinance was passed back in May. It became effective June 3rd. And it stops evictions. Let's see, I have some detailed. It actually stops evictions on residential properties or any place where an individual is dwelling based on any kind of eviction other than a tenant who is an imminent threat to health and safety of other occupants and tenants of the same property. Now we're talking about the tenant themselves is the risk to health and safety, not that the property itself is unhealthy or uninhabitable. So the question has been, what does that mean? When is a tenant an imminent health or safety threat? As I was reading, one extreme interpretation of that is that the tenant has been guilty of a crime, the tenant has been convicted of a crime. On the other hand, some of the situations that I've puzzled over and considered whether it's worth a try is, that the tenant has caused a flood that affected the neighbors and potentially may have caused mold or some, raised some damage or harm to the neighbors or other occupants of the same property. I don't have a lot of information about the evictions that have gone forward under this imminent health or safety threat, because I don't think there have been very many. The courts have been putting most evictions out until after August 14th, thinking that that was the expiration date. And then the other type of eviction that the San Diego County ordinance would allow to go forward is the SB 91 exception, where the tenant has failed to provide the COVID hardship declaration. And then if you choose to go forward on a non-payment of rent eviction against a tenant who received and then failed to return a COVID hardship declaration, meaning that, you know, they didn't pay rent, so you gave them their 15-day notice to pay or quit, which has to be coupled with the notice from the state of California explaining their rights under the COVID Tenant Protection Act, as well as a copy of the unsigned declaration for them to sign and return. If they fail to return that declaration, you may go forward with the eviction for non-payment of rent. However, they can present it to the court at any time. The tenant can just file it with the court, and the court has to schedule this COVID hardship hearing in which the case can be dismissed if the tenant comes forward and shows that they had some excuse for not providing the declaration in time, but that they actually do have a COVID hardship. So it becomes very risky in spending the time and money to go into court for non-payment of rent, but it is authorized under the county eviction ordinance. This ordinance is potentially retroactive to February 14th, 2020, when San Diego County first declared the local health emergency. But that retroactivity is under scrutiny, and there has been a legal challenge, although it has been kicked out of court. So I'll tell you a little bit more about that in a moment. Then there is also the requirement of special language that's required to be used in notices to tenants for non-payment of rent, specifically related to this county eviction ordinance, and it has to be in bold and underlined. And if your notices do not have that language during this period of time from June 3rd through August 10th, then that notice is invalid, and you'd have to start all over with a new notice and a new eviction if you violated the ordinance. Then other highlights from the San Diego County eviction ordinance: it forbids any waiver of rights, whether you entered into a stipulation with a move-out date in court with a tenant, whether the tenant has signed a settlement agreement or a cash for keys agreement, or even in a lease agreement that states that, you know, any ordinance is waived. None of those kinds of waivers would be enforceable. It's specifically forbidden. It also forbids a landlord from retaliating against tenants who disseminate the information about the ordinance. So tenants who talk to other tenants about the ordinance and about the fact that they can't be evicted right now, it's forbidden to retaliate. It requires strict compliance with the ordinance. It provides for injunctive relief to stop an eviction. Also monetary damages, whatever the tenant's actual out-of-pocket damages are as a result of the landlord's violation of the ordinance, and mental or emotional distress claims. It expressly authorizes tenants who feel subjectively that they have suffered emotionally from any kind of threat by the landlord, and a threat could be simply issuing a notice that violates the ordinance. If a tenant were to succeed in making a claim for mental or emotional distress and money damages, they may be awarded treble damages, 3 times the amount of whatever the court or judge or jury sees as an appropriate amount of damages for actual out-of-pocket and emotional distress. You multiply it by 3 if the judge or jury finds that the landlord knowingly or recklessly violated the ordinance. And the judgment could include attorney's fees if the lease provides for attorney's fees. So it's very serious and potentially a big judgment against a landlord for violating it. Oh, by the way, we don't foresee the possibility of this being extended. I was on the supervisor's website. There was no indication in the most recent agenda of any discussion of extending this, and we had some assurance from one of the supervisor's representatives. We checked in to see if there was any likelihood of it being extended, and they said no. That was several weeks ago, and so far I haven't heard anything differently. So the next big issue that we have been seeing, and I love this issue because this is the light at the end of the tunnel, is rental assistance. we are seeing disbursements to residential landlords for tenants who haven't paid their rent during COVID. So the COVID-related rental debt is any non-payment of rent dating back to March 1, 2020. So from March 1, 2020 through today and going all the way through the end of the California state eviction moratorium, which currently is scheduled to end September 30th, landlords can apply and tenants can apply for rental assistance through a website housing.ca.gov or housingiskey.com or through the San Diego Housing Federation. I'm sorry, I'm blocking it. Anyway, the first two websites are a good way to find the application for the rental assistance. And at first we didn't see any money coming out of it, but now not only are we seeing the money being dispersed to the landlords, and by the way, the money is dispersed to the landlord if the landlord cooperates with the application. The money is dispersed to the tenant if the landlord does not cooperate. So if the landlord cooperates, they can get 100% of the rent. The state is covering not just 80, it used to be 80%, now it's 100% of the past due rent if the tenant qualifies. Now, if the landlord does not cooperate, the tenant may get 25%, and it goes into the tenant's pocket, and it's up to the tenant whether they give the money to the landlord to cover some of the past due rent or not. People have checked in with me because they got the money and now another month or two has passed and the tenant still hasn't paid for those next months. Can they go back and reapply even if the tenant now seems to have a job? And the answer is yes. What these individuals, at least two of them I've spoken with, have been told is that, quote unquote, there's a pile of money that they need to give out. And so they should definitely continue to apply and reapply for the funding for all of the past due rent. And then as the months proceed for any future, not for future months, but in the future, for the past due rent. Now, the other interesting development, which is pursuant to AB 832, AB 832 was the legislation that passed at the end of June, which extended the statewide Tenant Protection Act of 2020, which is the COVID Tenant Protection Act. AB 832 included a new part of the law. It wasn't just a bunch of extensions, it actually added things. And one of those additions is that it is required by law for the landlord to apply for rental assistance before they may proceed with a non-payment of rent eviction. So even if the tenant does not return the COVID hardship declaration and you proceed with the non-payment of rent eviction and they still don't respond, it is now a requirement that the landlord provide proof that they applied for the rental assistance and that it was denied. They have to have written proof. That's a bit of a mystery because it's not always clear, it's not always clear how those applications are going to proceed, how quickly they'll proceed, and why or how they will be not granted. But anyway, that's the law now, and we'll see how that plays out in court. So this is just another reiteration of what I just said, and the other website is on here, the San Diego Housing Commission, sdhc.org website is another place to find the application for the rental assistance funds within the city of San Diego. And the authority, the administrative agency that gives out those funds depends on where the property is located. But if you go to the general websites, housing.ca.gov or housingiskey.com, it will direct you to the appropriate authority. So our update on the statewide the state of California moratorium, which, as I mentioned before, is called the Tenant Protection Act of 2020, or I also call it the COVID Tenant Protection Act of 2020. It began back in August 2020. It's been extended many times, most recently at the end of June. AB 832 extended it to September 30th, 2021. All of the dates associated with the COVID 2020 Tenant Protection Act have been extended through September 30th. And there is a later date for when landlords will be allowed to proceed to obtain judgments against tenants for the non-payment of rent. And that date has been extended to November 1, 2021. If you recall, there was the authorization to lift the cap on small claims judgments. Small claims judgments are typically capped at $10,000. And if you have COVID-related rental debt and you need to pursue a judgment against your tenant for that debt, small claims court will be allowed to issue a judgment without any cap, just for that type of rental debt. So that's rental debt owed from March 1, 2020 through the end of the eviction moratorium, currently scheduled for September 30th. But you can't proceed to small claims court until after November 1, on November 1, 2021. Also, you heard NAR's Representative Christy DeSanctis just a moment ago, indicating that the National Association of Realtors is really focusing on the rental assistance. I meant to mention this with the last slide, but I agree that the rental assistance program is really the way to go as far as trying to figure out the situation with the tenant. I am not trying to give everyone legal advice here. I don't want this to be considered legal advice to any particular individual, but I would say in general, every situation that I have discussed with an individual recently, with individuals recently, I have first recommended, if there is unpaid rent, to apply for the rental assistance, because it's unlikely that we would be able to proceed successfully with an eviction until that hoop has been jumped through. Okay, real quick, the California moratorium, once the county, San Diego County moratorium ends, we go back to the statewide moratorium. And under the statewide moratorium, every eviction in California, residential evictions, must be done with just cause. There are many areas throughout California where prior to COVID, you might have been able to proceed with an eviction without stating any cause at all. You could do a 30 or a 60-day notice, depending on the circumstances, and not even have to give any reason for the eviction. Now with the statewide COVID Act, we have to have just cause. So there are two kinds of just cause. There's at fault just cause, where the tenant is at fault. The tenant has done something that causes the landlord to want to terminate the tenancy, such as, you know, being a hazard to the health or safety of other occupants, defaulting in payment of rent, breaching a material term of the lease, but only if it's not related to a COVID hardship. If the breach could be associated with a COVID hardship, which in many cases, assigning and subleasing is considered associated with a COVID hardship, when people are doubling up for their housing, usually means that they can't afford to live on their own. And so if you then evict people for assigning or subleasing their lease, then you are causing people to then create greater occupancy of other premises. You know, you're kicking them out of here, they're going to go double up with somebody in another house. And so that's not going to be productive in trying to get rid of the pandemic. Nuisance and waste, where the tenant is actually destroying the property or doing something that is harmful to the neighborhood. The expiration of a fixed term lease, where the tenant knows that they're supposed to move out, they fail to move out. But under the COVID law, it requires that the landlord make a written request to renew the lease, and then the tenant has to refuse. And this has to be done in writing so that it's documented. Also, any proof of criminal activity, which means a criminal conviction. A tenant refusing to allow entry which is a very touchy situation. If tenant won't allow you into the property and they are claiming it's because, you know, someone is sick, they're afraid of COVID, arguably they might have a good reason not to allow entry. But the COVID restrictions did not change the landlord's right to enter. And so the landlord still has the right to enter, to show a property to a potential buyer, to inspect in order to make necessary repairs, to fix decorations. You know, all that statute that allows entry has not been changed under the COVID laws. There are some other reasons why we may be able to evict for the tenants at fault. And then no fault just cause definitions, once the county ordinance has expired, include, again, some sort of hazard to the health and safety of other tenants or occupants of the property. Maybe it's no fault of the tenant, but you know, you could argue this even under the county ordinance. But there are a couple that we have used prior to the county ordinance that have been very successful. And I think these were some of the main reasons why the county ordinance was passed. If a landlord intends to occupy the premises themselves or by their spouse, domestic partner, children, grandchildren, parents, or grandparents, then you can give a 30 or a 60-day notice for that reason. And that is an authorized reason to move forward with an eviction. Withdrawal of the property from the rental market, but only if the property is in escrow for sale to a bona fide purchaser, meaning they're paying fair market value, they are not a relative of the seller, and they intend to occupy the residence, and they're not a corporation. Orders by government agencies to vacate the premises, and then if the landlord has a reason that they have to do a substantial remodel that's necessary in order to bring the property up to code so that it's habitable, that may be used as a reason for the eviction as well. So then we've heard about the federal Centers for Disease Control eviction moratorium. I'm going to save some time for Q&A by skipping over this, since we've already heard this from Christine, and she did an excellent job of updating us on that. So then a question I'm getting very often is whether rent could be increased at this time. And the answer is yes. That's the simple answer. But then the longer answer is you have to look on a property by property basis to see if there is any rent cap limitation that applies to the property. Across the entire state of California, we have the Tenant Protection Act of 2019, which is, depending on the status of the property itself, if it's a more than just a single unit, so a duplex or more residential property, so 2 units or more, you know, this is the AB 1482 rule, and then you have to look at how old is the property. You have to look at the lease and notices to see if the landlord has claimed to be exempt from the rent cap. Okay, so that's a whole analysis that has to be done on a property by property basis. Section 8 has some limitations on increasing rent, and then anti-gouging statutes that are also statewide that limit us to a 10% increase on any 30-day notice. Though if you do a notice that's a longer notice, then for the most part, that rent cap goes away. And then finally, I just wanted to point out that, to my knowledge, the sheriff is still not really enforcing judgments for possession of the premises in a quick and concise manner. So, you know, we pursue an eviction, we get a judgment from the court, and then we have to process paperwork through the court to get a writ of possession. And then the writ of possession, you know, when we succeed in taking an eviction to trial and getting the judgment, this writ of possession is taken to the sheriff's department, and we pay the sheriff, not very much money, but we pay the sheriff to execute a lockout. And then they call us they post a 5-day notice to vacate, and then they call us when they are ready to go out and perform the lockout. What's been happening is the sheriff does post the notice to vacate, but there's no requirement that they execute the lockout pursuant to the date set forth in the notice to vacate. They actually have up to 6 months from when the writ of possession was issued by the court to execute it. So they can sit on the writ and just hold it and not do the lockout until they decide that it's appropriate. And so what the sheriff has been doing is they've been waiting, in my experience, a couple of months before they finally get around to them. There are supervisors in play where I believe that if there are other factors that might encourage them to execute the lockout, then they can choose to do them sooner or later. So that's a concern, that even when you do succeed in jumping through all of these hoops, that you still may have a problem actually getting the lockout done. So that's it for me. I would be happy to take some questions, and let me see what you guys have. I don't see too much going on in the chat. I have a question. Can I clarify the rental cap using the CPI that the county put in place? I was recently told by CAR Legal that my single home owner was not required to comply with the rent cap ruling of the county because it violated Costa-Hawkins, which they said would take precedence. That's interesting. I don't know about whether the county ordinance conflicts with Costa-Hawkins, but the county ordinance rent cap only lasted through July 1, so it has expired. The current rent cap that involves CPI would be the AB 1482 rent cap, where you have the 5% plus CPI. And based on what I've read on the Southern California Rental Housing Association website and heard from that organization, as well as in general, I've heard that CPI went up to 4.1%. And so it's 5% plus 4.1%. But what I recommend is that when you choose your rental increase based on CPI, that you look it up in some reliable source, what you're going to base your CPI on, and you save it in your file so that if you do end up in court on this issue, you have support for why you chose that number. And so the statute itself is so vague. It's so vaguely written. And CPI is such a general term. It means a lot of different things. You know, per CPI is based on different areas. It's based on different things like cost of food, cost of utilities. You know, there's all sorts of different CPIs. That being said, you can use that to your advantage, because as long as you have based your increase on something, the court, in my opinion, would have to go with it. So next question, can we even offer cash for keys at this time? Yes, I highly recommend if you have a problem, or if you have a tenant who's willing to move out based on a cash for keys agreement, I highly recommend that you attempt to do that. Now, usually we couple the cash for keys agreement with a written agreement, and the written agreement, until the county ordinance expires, the written agreement would not be enforceable, because it would be a waiver of the ordinance to have the tenant agree to a move out date. And I have also heard a more extreme viewpoint of the ordinance indicating that even the suggestion of a move out date to a tenant could violate the ordinance. My view is less strict in that I don't think that a tenant who agrees to a move out date and accepts money for moving out would have a claim that they suffered from having entered into that agreement. But certainly it's a very subjective standard where, you know, someone could still say, well, there's some circumstance where they felt compelled that they had to sign the agreement, or else something bad would have happened. And so if you're concerned in that sense, you might want to be careful. And it's just a few more days. So once the county ordinance expires, you'll be in good shape for continuing with those cash for keys agreements. They're not a violation of the statewide law. Next question, how is the San Diego County ordinance set to expire on August 10th, potentially retroactive to February 2020? I thought expired means no longer in effect, right? So during its effective time period, the way that it was written, if you read the express terms, it dates back to the beginning of the pandemic. So the way that it was written was, in my opinion, poorly written. It said that it invalidated any notice. It said that any notice that does not comply with the ordinance cannot form the basis of an unlawful detainer, which means that all of those notices going all the way back to the beginning of the pandemic that don't comply with the county ordinance could have been invalidated. The question becomes, do they have authority to do that? And the lawsuit intending to challenge that has been kicked out of court. By the way, I forgot to mention that. So that there was a federal lawsuit by the Southern California Rental Housing Association. And by the way, it is on appeal because what happened is that the county challenged the lawsuit, and the judge in the federal court agreed to grant a motion to dismiss, not agreed, but granted a motion to dismiss the case. And so the Rental Housing Association has appealed it to the Ninth Circuit Court of Appeals. And we'll see what happens there. But that is the lawsuit, as far as I know, that would challenge the retroactivity of this ordinance. But on the other hand, we are waiting to see when these cases are allowed to move through the court. The court has there's a very long queue of cases that the unlawful detainer court, Department 60 in San Diego County, has put out until after the ordinance expires. Among the attorneys I've spoken with, we don't expect the court to invalidate notices that were issued prior to the ordinance that don't comply with the ordinance, because they were issued prior to it going into effect. So there was no due process. There was no notice of how to comply until the ordinance went into effect. So things during the ordinance that don't comply would probably, if you filed a suit and you're not in compliance during the time period of the ordinance, then your case might get kicked out. But we think that all of the things that have been pending since prior to the ordinance that will now go back into court after it expires will probably be able to just continue as though the ordinance never happened. But we don't really know. It's very unclear. I'm not sure if that really answers your question. It's a complicated legal question, the issue of retroactivity and due process and all those things, constitutional issues. Next question, can I give 60-day notice to move out to sell the property? Tenants have never claimed a hardship and paying rent on time. After the ordinance expires, they're under the statewide, the Tenant Protection Act of 2020, you can do a 60-day notice to the tenants if you can check all the boxes. You're selling the property, you're in escrow to a bona fide purchaser. Bona fide purchaser means that you're selling at fair market value and it's an arm's length transaction. You're not selling it to your relative. And the buyer has to intend to live in the property, and the buyer cannot be a corporation. If you can check all those boxes, then yes, you can do a 60-day notice and evict the tenant while you're in escrow. If you close escrow, then the game changes. So that's a case-by-case basis type of situation. Next question, my client has tenants who are current clients with payments. The lease is up on 8/31/21. She wants to sell the property. What does she need to do with respect to the moratorium? The end of the lease is not going to suffice to be a reason for eviction. selling the property alone is also not a reason for an eviction. There are additional steps that have to be taken in either of those. Those are two separate potential reasons, but I just explained the one about selling the property to a bona fide purchaser, fair market value, and the buyer has to intend to live in the property and cannot be a corporation. The other one is let's see, the lease, expiration of a fixed term lease, the landlord has to offer a new lease with similar terms in writing. So if it was a 1-year lease, you have to offer a new 1-year lease. Similar terms also, you can't raise the rent more than, the allowable amount, or not, don't raise the rent too much. If you need to raise the rent a little bit, that's probably fine. And if the tenant accepts, you can't evict them. But if the tenant refuses to sign the new proposed lease, then you can use that as the reason for eviction. You've presented the written lease, they refused to sign the lease. You have to gather evidence and have some proof that they refused, so that they can't walk into court and say, oh, they do want the lease after all. And anyway, hopefully that makes sense. If your tenant will not cooperate or provide any COVID hardship information, how can you apply for relief as an owner? Cannot even tell if the tenant's income falls within the guidelines. You can still apply through the website, and if the tenant doesn't respond, or if the tenant doesn't qualify, then the application will be rejected. And at that point, you can move forward with the eviction. If they haven't paid rent, if they haven't given you the COVID hardship declaration, then you would be able to proceed with an eviction for non-payment of rent. There are so many reasons why that eviction might not work out in court, but if that's your only choice, then you might go forward with an eviction under those circumstances. Another question is, an adult boyfriend moved in without permission. Can we give notice for him to vacate after the 10th? That would be a sublease, and subleasing is generally considered, we assume when subleasing is the issue, that a COVID hardship declaration would prevent the case from moving forward, because subleasing is considered related to finances, related to COVID hardship, and kicking people out of properties so that they then go and sublease from others would be part of the policy that they want to prevent. They want to prevent the higher density of numbers of people living in the same household if possible, because of the pandemic. The housing assistance looks like it's available for tenants that are below a certain income level. Is there any option for a homeowner for higher income tenants? I don't know. I haven't looked very carefully at the guidelines for the rental assistance. I think you just have to try it and find out, because I think the guidelines also change regularly depending on how much money is available and who's applying for it. I can't say much more because I'm guessing. I don't really know. I would go to the website and see if any of that information is on there. So that's housing.ca.gov or housingiskey.com. So the Southern California Rental Housing Association lawsuit under appeal is the only one challenging the retroactivity of the ordinance. To my knowledge, that's the only one I know of. And they asked for joinder from other parties. They were not trying to do a class action, but they did ask for people to submit themselves if they thought that they might be a good plaintiff in the lawsuit. And what if a tenant is verbally abusive and hostile to the landlord? Does that justify noticing? I assume you meant noticing their eviction. Not usually. I've explained, I don't know how many times in my career to landlords and to tenants alike that having a bad personality is not a breach of contract. And unfortunately, that's true. So being verbally abusive is not going to justify an eviction. And in fact, domestic violence can prevent you from being able to evict someone, especially primarily if they're the victim of domestic violence. But what often happens is the domestic violence is a two-way street, and there might be some restraining order issues, but ultimately, you know, when domestic violence has taken place and the tenants are involved, it can become a much more difficult eviction because that becomes an issue, and there is a statute that protects the victim of domestic violence from being evicted. All right, I think that's all the questions. I don't know if I think I've got some other, oh, I've got some other Q&A here. Okay. If the tenant hasn't paid rent in 3 months, when should they give notice to move out? You can give notice every single month when a tenant has not paid. You have to do the 15-day notice, the notice from the state of California, and the COVID hardship declaration. And then the tenant has an opportunity to return the declaration. And if they do return the declaration, then you should not proceed with the eviction because they are protected. They still will have to pay the 25% of the rent that's due, at least 25% of the rent that's due, in order to continue to be protected after September 30th. As many of you have observed, that date was originally 25% was due by the end of January, and then we might have proceeded with evictions on February 1st, 2021, but then it got continued to, I forget all of the interim extensions, but then I think it went to June 30th. And we were thinking maybe we'll be able to move forward on July 1 with some non-payment of rent evictions when people don't pay the 25%. But now that's been continued to September 30th. So now that 25% would be due by September 30th. And if people don't pay the 25% by September 30th, we might be able to proceed with those evictions starting October 1. And we have a queue of people who are waiting to see when that date arrives so that they may be able to move forward. But if they pay the 25%, they are protected for another year. And then, you know, October 1 arrives. If they don't pay the October rent, if the moratorium expires on September 30th, non-payment of rent for October will be fair game. We'll go back to the regular eviction process where you would give the, I'm going to stick with 15-day notices for a while because I'm told that they might keep that part of the law. There's a lot of ambiguity. Again, I'm sorry, I can't be more specific, but all of these, so next question, all of these seem directed at actual evictions. What about regular lease terminations? Can an owner give a tenant whose lease is expired so that they can sell the property? You can give a notice to the tenant, and if the tenant leaves voluntarily, that's great. You don't need an eviction, but the problem arises when you need to enforce the notice. So you need to make sure your notice is enforceable in court just in case. Okay. When the local county ordinance is lifted, presumably on 8/10, can we raise rents again based on the state rent cap laws, 5% plus inflation for homes covered by the law? The county ordinance rent cap expired on July 1. So we went back to all of the old rent cap issues after that. So on a case-by-case basis, you have to determine whether there's a rent cap that applies to the specific property. But the COVID restrictions did not change the rent cap other than that less than 1 month rent cap restriction from San Diego County, which has expired. Next question, it does not prevent cash for keys, does it, as long as you don't have any waiver of rights? You merely say, I will pay you if you move out. Yeah, so that's correct. The standard cash for keys agreement is an more of like a transaction. And if you don't put it in writing, you can still execute a cash for keys agreement verbally by agreeing on a date, going to the property on the agreed upon date, meeting the tenant outside. I recommend walking the property to confirm that the tenant's belongings have been removed and there's no major damage or, you know, reason why you wouldn't want to give the tenant the money. But before you give the tenant the money, you go back outside of the property, have your locksmith or your new lock set ready. You hand them the keys, they symbolically, you hand them the money, they symbolically hand you the keys, and then you change the locks. But as an attorney, I recommend, first of all, putting the agreement in writing, and then on the date of the exchange, having another document to sign saying that they acknowledge that they have moved out on this date, so that you have this second reason. And then the cash for keys agreement itself is not enforceable, but in effect, if they don't comply with it, they don't get their money. So typically it works out, and we don't usually go to court to enforce those anyway. Thank you for the nice comment. Can I talk about, you asked me, can I talk about raising rents on what are the limits in San Diego County? That's really a lengthy discussion for another time, but as I've mentioned, it's a case-by-case basis. You have to determine what, if any, rent cap applies to the property, and there is a statewide anti-gouging statute that applies. There are other rent cap issues that apply if there's a state of emergency, which we have had because of the pandemic, and we've had for other reasons too, you know, fires. So it's really a very broad area of the law to say, you know, can you talk about all the different rent caps? I can't really at the moment, but maybe we'll do a separate webinar on rent caps sometime. Next question. I have a client that had a non-paying renter from February 2020 to October 2020. But the renter died in October 2020, so was not able to get the tenant to fill out the forms. Tenant did not die of COVID reason. My question would be whether the tenant has an estate. And even if the tenant has an estate, like in probate, or a trustee, meaning that potentially their interests pass along to their beneficiaries, I'm not sure whether the state of California or the authorities who are doing the rental assistance would issue the rental assistance to an estate of a person who has passed. So I still say it's worth asking, and if you can reach someone to ask the question whether you could have their personal representative apply, that might be worth doing. Next question, assuming that Gavin Newsom is recalled, which is highly likely, how will that change California property management regarding these issues? I don't think that recalling the governor will change any of the laws that have been passed. I guess there is a procedure to repeal laws after they've been passed, and maybe that there might be some effort to do that, but I just recalling the governor alone wouldn't change any of what I've talked about today. Question, are evictions allowed as a result of sale of the property to a buyer who intends to occupy? Evictions are allowed prior to the sale. So, you know, the way the question is asked is a little bit difficult. It's ambiguous because the question is as a result of the sale. No, if you sell the property and then the new owner tries to evict the tenant, they no longer have the reason that it's being sold to a bona fide purchaser. That reason goes away at the close of escrow. What you need to do is pursue the eviction prior to the close of escrow and complete the eviction prior to the close of escrow, in my opinion. I don't know if you could argue that once you file the lawsuit, it might pass along to the buyer. You know, the buyer takes the property subject to the pending lawsuit, and the tenant's tenancy, which is also the buyer receives the property subject to the tenant's current tenancy, which is already subject to an eviction. You know, you might argue that it continues, but I wouldn't risk it. I would try to complete the eviction before close of escrow. So after August 10th, landlord can serve a 60-day notice to a tenant citing substantial remodel and repairs. Yes, but it's more specific than that. They have to be necessary to bring the property up to code with regard to issues of habitability. So, you know, it can't just be, it has to qualify in the way that the statute is written. And I don't have it on hand, but, oh, I do have it. Okay. Let's see. Termination of a tenancy based on the intent to demolish or substantially remodel the residential real property shall be permitted if necessary to maintain compliance with the requirements of section 1941.1 of the Civil Code, section 17920.3 or 17920.10 of the Health and Safety Code, or any other applicable law governing the habitability of residential rental rights. So that's where that one sits. You know, I'd have to go into court trying to prove that it qualifies under those qualifications. I am out of time.
Shanna, thank you. Then we'll try to put together some more programming in the future, everybody. Shanna, really appreciate you, and thank you all for being here today.